All right, let's get into it. Today, we're going to unpack the story of the UK's Human Rights Act. And it's this really fascinating story of how a country, with no single written constitution, came up with this kind of unique solution to protect people's fundamental rights. It's all about trying to find this very, very delicate balance between the power of Parliament and the power of the courts.
Just think about that for a second. In most countries, you can go to a Bill of Rights or a constitution, point to a line and say, right there, that's my right to free speech. But for most of its history in the UK, nope, that just wasn't a thing. Your rights were basically everything the law hadn't gotten around to banning yet. So how on earth did that actually work? And what pushed them to make such a big change?
So to really get a grip on the Human Rights Act, we've got to rewind the clock a bit. We need to go back to what things were like before the year 2000 when it all came into force. This was a totally different world, the era of, rights without a bill.
Now, this quote here is fantastic because it tells you so much about the old way of thinking. This is from A.V. Dicey. He was a giant in British constitutional law. And for him, and a lot of people like him, not having a big formal Bill of Rights, that wasn't a mistake. No way. It was a feature, not a bug. It was what made the British system, British, and different from places like France or the US.
And look, this wasn't some dusty old idea from the 1700s. We're talking 1958 here. You can still feel this real sense of pride, almost a bit of swagger about it. The whole attitude was, sure, other countries have their fancy bills of rights, but those are just words on paper. We deliver the real thing, actual, practical freedom. So what on earth did they mean by liberty according to law?
Okay, so this is the absolute key to understanding the whole thing. It's what lawyers call negative liberty. Think of it this way. Instead of the law handing you a list of things you are allowed to do, it just tells you the things you can't do. And your freedom, it's everything else. Everything that's not on the no list. It's a clever idea, but you can see the problem, right? The protection is a bit shaky. What's to stop Parliament from just waking up one day and adding a bunch of new things to the no list?
And that question right there, that's exactly what brings us to our next chapter. Because that traditional system, which sounded so neat and tidy on paper, started to look, pretty flawed in the real world. The cracks started to show, and they just got bigger and bigger until they were impossible to ignore.
Yeah, this table just lays it all out. The protection you got from the courts was, to put it mildly, a bit of a lottery. You see, in one case, way back in 1765, Antic versus Carrington, the court is this fierce defender of private property against the government. Fantastic. But then, fast forward to World War II, in the Liversidge case, and the court basically says, whatever the government thinks is best. A totally different approach. And then you get this Malone case in 1979 about phone tapping. The court's reasoning was basically, there's no law saying we can't tap your phone, so it must be fine. You can see why people started calling it an erratic system.
Okay, let's move away from the legal theory for a second and talk about real people. This is the Smith case from the mid-90s. The UK's Ministry of Defence had this policy, a total blanket ban. If you were gay and serving in the military, you were out. Just like that. So 4 service members, people who were serving their country, challenged this policy. And the whole thing boiled down to one simple question. Was this legal?
So the case goes to the UK courts, and the judges use this standard called anxious scrutiny, which sounds really intense, right? It means they're supposed to look really, really closely at what the government's doing. But here's the thing. Even after all that anxious looking, they said the policy was lawful. Their logic was, look, our job isn't to say if this is a good policy. Our job is just to ask if it's so completely irrational that no reasonable government would do it. And they decided, nope, it passed that test, so the policy.
But the story doesn't end there. This is where it gets really interesting. The service members, they didn't give up. They took their case all the way to the European Court of Human Rights in Strasbourg. And that court, it had a completely different take. They said this isn't about reasonableness. This is a clear violation of a person's basic right to a private life. And just like that, you had this huge, glaring contradiction. The exact same policy was illegal in a European court, but perfectly fine in a British one. It just showed everyone how big the gap in protection really was at home.
You can imagine, cases like Smith just poured fuel on the fire. People started saying, hang on a second, this is crazy. It took years, it cost a fortune, to go all the way to a court in France, just to get a right enforced that the UK government had already signed up to internationally. The argument became overwhelming. Why can't we do this here? It was time to, as the slogan went, bring rights home.
And looking at this timeline, you see this wasn't some snap decision. The weird thing is, the UK was actually one of the very first countries to sign on to the European Convention on Human Rights, the ECHR, way back in the early 50s. By 1966, they even said, okay, our citizens can take their cases to the European Court. But for decades, that was it. The rights were over there, not here. It wasn't until the new Labour Party in 1997 made it a promise in their manifesto that things really finally started to move.
So the arguments for the act were pretty straightforward and honestly very compelling. First off, just the common sense of it all. Let people fight for their rights in their own country in front of their own judges. It's faster, it's cheaper. There was also this bigger hope that it would create what they called a culture of awareness of human rights. Make government officials actually think about this stuff before they make a policy. And I love this last point. The idea was for this to be a floor, not a ceiling. A baseline of protection that Parliament could always build on but shouldn't really go below.
But, of course, it wasn't all smooth sailing. There was a lot of pushback. The biggest fear, the one that came up again and again, was about something called parliamentary sovereignty, this core principle that the elected parliament is the ultimate boss. Critics were terrified that the act would just wreck that. They worried it would hand over way too much power to judges who, remember, aren't elected, and let them start making decisions about politics. That wasn't their job, according to the critics.
And they even came up with this great word for their nightmare scenario, a juristocracy. It's a fantastic word, right? It perfectly captures that fear of a country run by judges. The worry was that suddenly, on all these really tough, controversial issues, the final say wouldn't come from elected politicians in the House of Commons, but from a handful of judges in a courtroom.
So that was the puzzle, a massive one. How do you protect people's rights without accidentally creating a juristocracy? How do you bring rights home but still keep Parliament in charge? Well, the answer they came up with was incredibly clever, and you might say incredibly British.
Okay, so here's part one of the big solution. It's called Section 3. And what it does is it tells judges, look, from now on your default setting is changed. Whenever you read any law, you have to try, as far as it's possible, to read it in a way that fits with these human rights. The best way to think about it is like they were given a new pair of glasses, a special human rights lens that they had to put on every single time they looked at the law.
But then comes the really big question. What happens if you just can't? What if a law is written so plainly, so obviously, that there's no way to make it compatible with human rights? And this is the genius of the whole thing. Unlike, say, the US Supreme Court, courts in the UK cannot just kill a law. They can't strike it down. Instead, all they can do is issue what's called a Declaration of Incompatibility. It's basically a giant, bright red flag they raise for Parliament to see. They're saying, hey, over here, this law you wrote, it's a problem. But, and this is the absolute key, the law stays on the books. It's still valid. The ball is now officially in Parliament's court. The elected politicians, not the judges, get the final say.
So at the end of the day, the Human Rights Act didn't create a judicial veto. It didn't create that juristocracy everyone was so afraid of. What it created was a conversation, a dialogue between the courts and Parliament about what our most basic rights actually mean in practice. It was this really unique attempt to get the best of both worlds, strong rights, but also a strong democratic Parliament. And the big question we're all still asking today, decades on, is that delicate and sometimes pretty tense conversation still working?